Specific denial. The purpose of requiring the defendant to make a specific denial is to make him disclose the matters alleged in the complaint, which he succinctly intends to disprove at the trial, together with the matter which he relied upon to support the denial. The parties are compelled to lay their cards on the table. So how is specific denial made? There are three modes of specific denial. Rule 8, Section 10 of the Rules of Civil Procedure contemplates three modes of specific denial, namely, number 1, by specifying each material allegation of the fact in the complaint, the truth of which the defendant does not admit, and whenever practicable, setting forth the substance of the matters which he will rely upon to support his denial. Number 2, by specifying so much of an averment in the complaint as is true and material, and denying only the remainder. And by stating that the defendant is without knowledge or information sufficient to form a belief as to the truth of a material averment in the complaint, which has the effect of a denial. In other words, the three modes of specific denial are: number 1, specific absolute denial, by specifically denying the averment and whenever practicable, setting forth the substance of the matters relied upon for such denial. Okay? Number 2, partial specific denial, part admission and part denial. And disavowal of knowledge, which is by an allegation of lack of knowledge or information sufficient to form a belief as to the truth or falsity of the averment in the opposing party's pleading. Here is an example of making specific denials, the case of PBCom versus Spouses Go. So on the fact of default, PBCom alleges in paragraph 8 of the complaint that Go defaulted in the payment for both promissory notes, having paid only 3 interest installments covering the months of September, November, and December 1999. In the answer, Spouses Go denied the said allegation, and further allege in paragraphs 8 to 13 that Go made substantial payments on his monthly loan amortizations. Moreover, in paragraph 10 of the answer, Spouses Go also denied the existence of prior demand alleged by PBCom in paragraph 10 of the complaint. They stated therein that they were not aware of any demand made by PBCom for the settlement of the whole obligation. Okay, another allegation. Finally, as to the amount of the outstanding obligation, PBCom alleged in paragraph 9 of the complaint that the outstanding balance on the couple's obligations as of May 31, 2001 was over 21 million pesos for the first loan and over 95 million pesos for the second loan, or a total of over 117 million. In response to this, in paragraph 9 of the answer, Spouses Go, without stating any specific amount, averred that substantial monthly payments had been made and there was a need to reconcile the accounting records of the parties. Question: did the Spouses Go make appropriate or proper specific denials? The Supreme Court answered in the affirmative. It held that clearly then, when taken within the context of the entirety of the pleading, it becomes apparent that there was no implied admission and that there were indeed genuine issues to be addressed. Okay, how about failure to specifically deny? Let us discuss the case of Freelo Construction versus Aegis Integrated Structure Corp. Respondent's averment in paragraph 4 of its complaint reads, "Payment of the sum of 6,024,306 pesos has long been overdue, in that respondent had long supplied, fabricated, delivered, and erected the structural steel requirements of petitioners, but the latter has paid respondent the sum of 4,490,014 pesos and 32 centavos only, thereby leaving an unpaid balance of over 1 million pesos. Petitioner denied this by stating in the answer. Similarly, petitioner also denies paragraphs 4 and 5 for being contrary to the facts and circumstances surrounding the case. Was there a valid specific denial? The Supreme Court held that petitioner did not make a specific denial, but a general one to the effect that it no longer has any remaining liability to respondent. Okay, let us go back to the answer. Petitioner in the answer provided that petitioner also denies paragraphs 4 and 5 for being contrary to the facts and circumstances surrounding the case. However, petitioner did not state the facts and circumstances surrounding the case, the matters which it relies on to support its denial of its liability in the amount of over 1 million pesos, and petitioner only asserted that respondent failed to show evidence of its supposed remaining liability. This is not an assertion of the truth and substance of the matter. It is merely a statement that as far as petitioner is concerned, respondent does not have evidence to prove its claim. The Supreme Court also held that the generality of the denial betrays the absence of specific facts that can prove payment. If untrue, the falsity of the alleged remaining balance in the amount of over 1 million pesos is wholly within petitioner's knowledge, which it should have delineated in its answer. Petitioner could have given specifics on why the original contract price of over 6 million pesos as evidenced by the purchase orders was performed only partially, thus prompting petitioner to pay only the amount of over 4 million pesos. Since respondent alleged its complete performance of its obligation under the purchase orders, petitioners should have asserted respondent's partial and incomplete performance, specifying the deliveries that were not made. In particular, petitioner ought to have alleged in the answer itself the structural steel requirements that were not erected such that it rightfully only paid for the lesser amount of over 4 million pesos. Yet, petitioner did not do so, and only insisted that respondent did not have evidence of completion and delivery. The Supreme Court further noted that the petitioner did not even attempt to allege via the third mode of specific denial, that is, that it had no knowledge or information sufficient to form a belief as to the truth or falsity of respondent's averments, because the knowledge or information on the issue at hand was clearly known to it. Petitioner simply avoided a direct answer to the allegations of respondent. Okay, so there was failure to specifically deny. Okay, here is another case showing failure to specifically deny, Terania versus Desagon. The petitioner's denial in her answer consists of the following. Number 1. Maliban sa personal na katangian at tirahan ng nasasakdal, ay walang katotohanan ang mga isinasakdal ng nagsasakdal. Number 2. Na hindi lumabag sa kasunduan ng upahan ang nasasakdal. And number 3. Na ang pagpapagawa ng bahay na inuupahan ng nasasakdal ay sa kaalaman at kapahintulutan ng nagsasakdal at higit na gumanda at tumibay ang bahay ng nagsasakdal sa pamamagitan ng pagpapagawa ng nagsasakdal. The Supreme Court held that we do not find this denial to be specific as the petitioner failed to set forth the substance of the matters in which she relied upon to support her denial. The petitioner merely alleged that consent was given. How and why, she did not say. If indeed consent were given, it would have been easy to fill in the details. She could have stated in her pleadings that she verbally informed the respondent of the need for the repairs or wrote him a letter. She could have stated his response and how it was conveyed, whether verbally or in writing. She could have stated when the consent was solicited and procured. These she failed to do. Ergo, the petitioner is deemed to have admitted the material allegations in the complaint. Let's talk about the third mode of specific denial. Without knowledge or information sufficient to form a belief as to the truth of a material averment. Section 7 of Rule 9 of the Rules of Court, in allowing the defendant to controvert material averments not within his knowledge or information, provide that where the defendant is without a knowledge or information sufficient to form a belief as to the truth of a material averment, he shall so state, and this shall have the effect of a denial. This form of denial was explained by the Supreme Court. Just as the explicit denials of an answer should be either general or specific, so all denials of knowledge or information sufficient to form a belief should refer either generally to all the averments of the complaint thus intended to be denied, or specifically to such as are to be met by that particular form of plea. The answer should be so definite and certain in its allegation that the pleader's adversary should not be left in doubt as to what is admitted, what is denied, and what is covered by denials of knowledge or information sufficient to form a belief. Under this form of denial employed by a party, it would be difficult, if not impossible, to convict him of perjury, if it should transpire that some of his denials of knowledge, etc., were false, for he could meet the charge by saying that his denials referred only to matters of which he had in fact no knowledge or information. In this case, the Supreme Court held that this form of denial, adopted by a party, although allowed by the rules of court, must be availed of with sincerity and in good faith, certainly neither for the purpose of confusing the adverse party as to what allegations of the complaint are really put in issue, nor for the purpose of delay. This rule, specifically authorizing an answer that defendant has no knowledge or information sufficient to form a belief as to the truth of an averment, and giving such answer the effect of a denial, does not apply where the fact as to which want of knowledge is asserted is to the knowledge of the court as plainly and necessarily within the defendant's knowledge that his averment of ignorance must be palpably untrue. What is the effect of failure to make specific denial? Material averment in the complaint, other than those as to the amount of unliquidated damages, shall be deemed admitted when not specifically denied. So the general rule is allegations not specifically denied are deemed admitted. Exceptions: allegations as to the amount of unliquidated damages, allegations immaterial to the cause of action, and conclusions of law. So these exceptions are actually not deemed admitted even if they are not specifically denied. When does a specific denial require an oath? A specific denial requires an oath if it is a denial of an actionable document, or it is a denial of allegations of usury in a complaint to recover usurious interest. Okay? Allegations of usury in a complaint to recover usurious interest are deemed admitted if not denied under oath.